This is a guidance that was issued a few months ago, and it talks about training programs that retailers can establish to help train their employees. This becomes important when you're talking about the enforcement of the reissued 1996 rule. And as we previously discussed, Congress gave the agency a lot of enforcement tools to utilize when we have identified a violation of the Tobacco Control Act. This is a list of some of the enforcement tools that we have that we can use against manufacturers, distributors, importers, retailers, anyone who's in violation of the Tobacco Control Act that we have jurisdiction to regulate. The first one is a warning letter. Now that's a letter that the agency sends to regulated industry identifying them of certain violations that we've identified at their establishment. The warning letter identifies which section of the statute and which section of the regulation that the company or entity has violated, and it asks them to submit a response to the warning letter identifying how they are going to come into compliance with the violation. Now this is a letter, and just notifying and warning the company that further enforcement action could be pursued against the regulated entity if they do not come into compliance with the statute or the regulation. The next enforcement tool is civil money penalties. Now that's a fine that we can assess against regulated industry for violations that we identify. The next one is no tobacco sales orders. Well, that's an administrative remedy to which we could issue an order to the retailer telling them that they could no longer sell tobacco products during a certain period of time. Next is a seizure order. That's the agency working with their colleagues in the Department of Justice and the U.S. Marshal's Office to seize violative product, to prevent it from moving into interstate commerce and to prevent it from being sold to consumers. The next enforcement tool is injunctions. This is a court order, and again, we work with our colleagues in the Department of Justice to file an action. It's a court action in which companies could be enjoined from further violating any of these provisions of the Tobacco Control Act or the regulations. Finally, we could refer the violations over for criminal prosecution. Now, the guidance covers many areas on implementing a retailer training program to your employees. The training program we recommend should include learning about the federal laws restricting the sale and distribution of cigarettes and smokeless tobacco products. There's also sections on how to request and to verify the photo identification of purchases younger than 27 years of age, and how to refuse the sale of cigarettes to purchases under 18 years of age. Now, under the Tobacco Control Act, it's not required that retailers have these training programs. We certainly recommend it. And as later slides will show, it's important for retailers to have these training programs when the agency pursues civil money penalties. Because as you'll see, the penalty fee structure that we can pursue against retailers for violations that we identify at your facility can be decreased if you have a retailer training program that has been implemented in your facility. The agency has issued this guidance, and in the guidance it gives our recommendation on the elements and things that should be contained in this training program for your employees. The agency, in the guidance, we identified that we plan to issue a regulation to identify the standards for a retailer training program. The retailer training program talks a little bit about the civil money penalties that we have authority under the Tobacco Control Act. It talks about how the penalty structure differs for retailers with this training program versus retailers who don't have this training program. And it provides recommendation as to the elements that should be contained in these programs. Now here is the schedule of fees for retailers who actually have a training program in place and has been implemented. For the first violation that the agency identifies at the retail establishment, the agency will bring a warning letter. For the second violation in a 12-month period, we can pursue civil money penalties up to $250. For a third violation identified in 24 months, we can pursue up to $500. Fourth violation in a 24-month period, up to $2,000. Fifth violation within a 36-month period, up to $5,000. And 6 or more violations in a 48-month period, up to $10,000. Now compare that to this fee schedule for retailers who have no program. First violation up to $250. Second violation in 12 months up to $500. Third violation within 24 months up to $1,000. Fourth violation within 24 months up to $2,000. Fifth violation within 36 months up to $5,000. And the 6 or more violations identified in a 24-month period up to $10,000. You'll see that it really affects the first 3 violations that we identify at that retail establishment. Now, what are some of the elements that we recommend be in this training program? Well, employees should understand that tobacco access and advertising restrictions, that they should understand and verify that customers are of legal age to purchase cigarettes and can successfully refuse the purchase of attempts to purchase cigarettes by minors. Again, what else should be in this program? The program should have the applicable laws and penalties explained to the employee. It should discuss the health effects of youth tobacco use. We recommend that the program have written company policies against the sales to minors, that it has a description of the products that you sell in your retail establishment that are covered by the laws. And it should have age verification law requirements, the right to refuse sales when you're acting in good faith, and the methods to ensure documentation that these employees have the knowledge required to comply with the new laws.